My name's Louise. I'm the Domestic and Family Violence Prevention Worker with Legal Aid Rockhampton in the Domestic and Family Violence Unit. And with me today, I have Charlie.
That's me. I'm the solicitor that's attached to the DV unit here in Rockhampton. My background's largely in family law, and I've done a bit of crime for legal aid as well. And then that has bled into the domestic violence unit here in Rocky.
Before we get into the topic of DVOs and family law pathways, I'll quickly run through the housekeeping for you. This webinar will be recorded and displayed on our Legal Aid's YouTube channel after the webinar. If you have any technical difficulties, please check out the GoToWebinar support webpage. The webinar will run for approximately an hour. That means we'll have about 40 minutes for the presentation and then 20 minutes for questions at the end. We have looked at your questions that people have pre-sent in, and we'll try and address those throughout the presentation. On the right-hand side of your screen, there's a sidebar. That's the control panel. You can download the handout using that control panel. You can also use the control panel to ask us a question. The screen is really little for us, but we'll attempt to. If we know that we're already going to address the question throughout the presentation, we might not address it straight away, but we'll try to get to all of your questions. Please hold your big questions for the end. I don't know how we define big questions, but like I said, we'll try and get through all of them. Now, how today will run, so it's not so boring, we'd love for you to interact with us. So we've included a few polls. This is our first one, and we want to find out a couple of things about you. So if you can, we'll start that for you and you can answer that. We'll give you a minute or so to respond from what region you work in.
I was just saying they should give us like little knots and crosses so we can, have something to do while the polls are up. Or tic-tac-toe, as they call it, where I'm from.
All right, I'm not sure who has put that in, but I think we then show you the results of that, maybe. Okay, so we've got a good majority of people from Rocky, a few from Yeppoon, a few from Gladdy, and other. Somewhere in between around the place. Okay, what's next? Do we have another poll, or are we're just waiting to see this next slide come up? There you go. Okay, so the next poll we're checking in with you about is what area of work you're in. If you would also like to please check your best option. We might give them a little bit less time to do this one, please. Organizer, I have an organizer in the background running this for us. It's our first time. So just bear with us today. This is a new thing for regional officers. We're trying this webinar today. So we've got Legal Aid Head Office running it for us. Hello to Jen and Tracy who are listening out there somewhere, who've just messaged me. Okay, has everyone voted for that one? I'll put the area in. We'll share the, no surprise, there's lots of community workers there, a couple of healthcare workers, financial counsellors, and people in education. Good to see a good variety in there. All right, well, I think I remember there only being 2 polls. We'll see when our next slide comes up. All right, so that's just a quick overview of what we're going to cover today. I'll just leave that there for a second for you to have a look, or if you've got the slides, you can follow along with the slides anyway. The next one, Edwina, please. The next slide. So the next one is just another quick poll, well, a quick question, just to see what you already know, because it's good to know where the gaps are so that we can, you know, maybe do another presentation or something different about what the gaps are, people that are tuning into these things. So just another quick question here. How you would rate your knowledge on the topic? Everyone should be right. I think should be long enough for those who wanted to vote. That's good. It's good to see that people are somewhat confident. Excellent. Well, hopefully you can re-poll yourself at the end to see if we've helped that in some way. So the next little poll is I'd like you to try and think about how many types of abuse do you think you can identify in regards to what would constitute domestic and family violence? We don't need to know the types. You can just keep that, note that yourself, but how many types you think you can identify already? Just give you a little bit of time for that one. I think that's enough. Yeah. Okay. We'll close that off. Good. That's great. Good to see that more than half of you can identify 7 or more. That's really good. Okay, so if you are following along with the handouts, or we're moving on to the next slide now, we'll talk about some of those behaviours. And so the behaviours that we're going to be talking about today are guided by our Queensland DV legislation. So as you can see by this slide, that the behaviour by a person towards another person, these are some of the things that constitute domestic violence. So physical or sexual abuse, emotional, psychological or verbal abuse. And it's quite interesting when we're doing this face-to-face and having conversations with people when we're delivering this. A lot of people can generally identify the physical or the verbal quite easily, but a lot of these other ones quite often get missed, especially economical abuse, though I see there's a lot more information out there now, so that's becoming more identifiable. And on the next slide, there's a couple more slides that show the rest of this. So really, when we're talking about domestic and family violence, we're talking about any behaviour that is controlling or dominating as to cause a person to fear for their safety, or quite often the well-being or safety of their children. And in beneath that, you've got another one there, cultural or spiritual abuse. So that's another one that's not often identified, but with all the information that we're putting out there now, that's becoming more, people are more on board with that. Then you've got all your forms of kind of technological abuse, so cyberbullying, harassment, Stalking, unauthorised surveillance, so maybe hanging outside someone's place of work or their home. Damaging a person's property or threatening to do so. And the biggest one we generally see is their phone. You know, when they're having an argument inside, you'll see the perpetrator will quite often smash the phone or take the phone so that the person can't call for help. Or in the bottom line there, having someone else to engage in that behaviour. So getting their family or friends to incite that violence or intimidation or harassment. So that's also constituted as domestic violence. So, I mean, and this isn't this is just based generally on the legislation, but if we think about lots of the different forms that we've seen over the time, so, you know, even, you know, things on, we talked about social media, so things on like Facebook, posting threats on Facebook, even threatening to out somebody in regards to their sexuality. What else? What is another one that you don't see too often?
Well, really the spiritually abusive element, which is often, it's often when it's there, it's very insidious, like sinister. We've, in the DV unit, I've come across it maybe 3 times in really clear-cut forms, and naturally it's each time it has been a male perpetrating domestic violence on that spiritual aspect, on the female relying upon tenets of their religion to establish his authority over her and try and get her to do what it is that he wants. Evidence-wise, all you really end up with is anecdotal, you know, her version of events. But I can also indicate that whenever I see, following the first instance of that rearing its head in the DV unit, getting that perpetrator into court and letting the court just see his attitude, that was evidence enough. And whenever we're talking about these types of domestic violence, it is important to bear in mind for the people that we're assisting to prompt them to, number one, be very clear about the types of domestic violence that they're talking about. But number two, using the tools at their disposal to produce the evidence of that type of violence. So when it comes to financial abuse, they can have, there will oftentimes be paychecks and bank statements that they can produce to corroborate what it is they're complaining about. When it comes to social media stalking, as Louise was talking about, screenshots and printed text messages are great. Where they'll, and the only thing really to watch for in terms of those of us in the support role for the victims is to also apply a little bit of reality testing to what they're complaining about. We're going to get into the intersection with family law a little bit later on, but I often see people complaining about bad parenting, trying to construe that as domestic violence. It's not, it's bad parenting. They'll try and construe arguments as domestic violence. That's not domestic violence, that's 2 adults talking to each other. So it becomes very, very important for those of us in the sector to have a keen eye on that first bullet point on the slide. In any way controlling or dominating as to cause a person to fear for their safety or well-being or that of someone else. So it's that control, that dominance. It's not having an argument, it's not being angry at each other. You know, DV can be very cold shoulder, it can be very insidious, it can be very gaslighty, you know, stalking, things of that nature. It might never get physical, it might never be as loud and as explosive as what we often see in media. It can be many things, but it is always controlling or dominating.
Okay, so we'll move into the part of the domestic violence orders. So at court, for a domestic violence order to be made, the magistrate has to be satisfied of 3 things. So we're going to cover those things. And the first one is that there's a relevant relationship as defined underneath the Act. So the relevant relationships are up on your screen now. So, and your obvious intimate personal relationship where it's a couple, married couple, or have been married, now separated or divorced. So a spousal arrangement, engagement, or an intimate, like a girlfriend, boyfriend couple that have been in a relationship. Family relationship. So can be siblings like aunties, uncles, cousins, nieces, nephews, as it says they're former, so like a previous marriage. Or in regards to Aboriginal and Torres Strait Islander people, the family relationship is extended a little to the point where if you regard them as a relative. So we quite often hear the term like they might call them auntie, or so if that person regards the other person as a relative, then there is a that can be deemed a relevant relationship underneath the Act, under the Act. So that's the, there's more on the next slide, please. The other form of relationship under the Act is what's called an informal care relationship. So as we've written up on there, it's someone that depends on another person for help in their day-to-day living. And that doesn't, though, include someone who is a carer employed under a commercial agreement. So it's someone that might be a friend that lives in the same house and is deemed their carer, that's providing that day-to-day help, like they need them to be in that situation to help them with their day-to-day living. So, and probably this one here is a big one to keep an eye out for, because it's probably the most underreported form of domestic violence. Because if we think about this in real life, that person is dependent on the other person, their carer, for lots of things. And if one of them is getting out into the public or seeking assistance from services, well, then that person has got control over that. And if they're inflicting any forms of domestic violence, then it's very hard for that person who's reliant on their carer to be able to report that or to seek help from other services. So that's a really big one to look at. And you know, if you have a little red flags, then ask some questions. You know, try and find out what you can about the relationship when they're by themselves or something, that you can get further information. Very much underreported, I would think.
And really ugly too.
Yeah, we've seen a couple of cases in the DV unit.
Really only two. Yeah, really only two that I can think of. Well, and one in particular, I mean, it was adjacent to this because she was also his estranged spouse. But we had a fellow that was he was in a, talk about bad luck. He was in a series of car accidents and then had a stroke. And so he was in a bad way. Funny guy though, great outlook on life. But before he effectively was rescued by family members, his estranged spouse was his carer. And she neglected him to the point where he had a urinary tract infection that damn near killed him. The medical evidence that they were able to produce in relation to, actually he was resisting a protection order that she was applying against him. It was an incredible matter. But the medical evidence they were able to produce indicated he was about 24 hours away from going into toxic shock and dying. The other matter we came across was equally ugly, insofar the person was wheelchair bound, and they would be their carer would wheel them into the shed in the backyard and leave them there for days. So it gets really nasty. What we've seen on the carers front. That's just some flashy, dramatic stuff to keep everybody awake.
So we're just before we started this relevant relationships, I said to you that there was 3 things that a magistrate had to be satisfied before issuing a final order. So the first one is the relevant relationship. A second one is that there has been a domestic, or more than likely been a domestic act of domestic violence. So we covered some of those types of abuse earlier in the thing. And for a final order, and I'm not sure if we talk about this later, but for a final order to be made, that it has to be necessary or desirable. Anyway, but for a temporary order, it's only the first 2 ones have to be, the magistrate has to be satisfied. So a relevant relationship and that an act of domestic violence has occurred. So moving on, we'll talk about what types of domestic violence applications there are. So there's a police application. So most of the time now, the police protection notice are what comes before the court. So that's an order that the police have taken out on behalf of the aggrieved, where they've been to an incident or an aggrieved has gone into the police station and provided enough detail for the police to take that on. But most of the time, the police protection notice is taken out when police attend an incident. So the difference between a police application and a police protection notice is that the police, and like I said, the police applications are a little less used these days, because the police protection notice gives the aggrieved immediate protection. So the police will go out and do this notice, and they'll serve it on the respondent as soon as they can locate them. But that order is then effective immediately. It doesn't need to go before a magistrate before it becomes effective. So that's the good thing about the police protection notice, and that's how most of them are carried out now. And once they, so the police protection notice will just be a little carbon copy, like a yellow, green or pink copy. And later on, when the police have done their statement up, they'll attach the actual application outlining the facts. But the police protection notices, like I said, are a good step forward in that they are effective as soon as they are issued.
And they last
until the court date. Yeah, so they're in place until the court date set down that they arrange with the courts. So they're your police applications. And the other one, of course, is that an aggrieved can take out an application herself or himself. So a private application, and they can get help with that, or they can do that online. There's a number of services around town now that are helping to do that. Relationships Australia and Rockhampton are funded to provide that service, but I know that you can, the police can help you also fill out an application and it still be deemed private. I know Central Queensland Community Legal Centre will help do that. And if need be, then Charlie and I back up doing that. But we're very lucky here that we have the assistance of those other services in Rockhampton to assist with that. Now, we've added in here from our previous presentations the word undertaking. So we just want to quickly touch on that. It's where 2 parties come to court, and it's quite obvious that one party might not be going to agree to a protection order for a number of reasons. It could be, and this is by no means no excuse for the domestic and family violence that's occurred, but it could be for reasons that it may impact on someone's employment, which isn't considered when it goes to hearing, because if they've committed the acts of domestic violence, and that's proven that it's committed. But an undertaking is a piece of paper that 2 parties can reach, and and this is generally in private matters though, not particularly, doesn't happen when it's a police matter. An undertaking is when 2 parties can reach an agreement that they will be, or one party will be of good behaviour towards the other, instead of going down the path of actual registered domestic violence order.
Yeah, when I use undertakings a lot up at court. That incident that I was telling you about previously, where old mate had the urinary tract infection, that matter was resolved by way of an undertaking in a circumstance where it's a good example because in mixed company, you don't really want to be talking about people making spurious domestic violence claims, but it happens, and that was one of them. And the matter was going to proceed to a hearing. It was going to be a huge hassle for the court. It was going to be very unpleasant for my client. And it was also going to be very unpleasant for the aggrieved, the applicant aggrieved. So when I spoke to her about getting the matter resolved, she was adamant that she was the victim. And it became clear to me that what she was seeking was a way out. She needed something to land in the win column for her. And the undertaking was an excellent option. That the undertaking, as I explained it to her at the time, it is a promise to the court. So it's a very serious document. And if someone gives their undertaking, the court takes it very seriously to the extent that a flagrant breach of an undertaking can be construed as contempt of court, and that carries a maximum penalty of 12 months in prison. So it is very serious, although it is not enforceable like a protection order. The term breaching an undertaking isn't going to activate any sort of criminal charges by police per se at first blush. But what it does do then is allow parties to effectively hit the pause button on proceedings, and whoever has the benefit of the undertaking being given to them can then if domestic violence continues, they can restart or re-enliven their protection order application based on the evidence that they should have of the breach of the undertaking. So it's a very, very helpful tool when considering the practicalities of legal proceedings and legal processes. There was a question that came through prior to today's webinar about effectively asking in an inadvertent way about vexatious litigants. This is one of the best ways to stop proceedings that do not need to be on foot, and it will also protect parties from that are making applications that do not need to be made. It'll protect them from any findings being made against them in the future as well. So there is something in it tactically for applicants that are doing the wrong thing.
And I guess just at the bottom of that slide, we need to point out that on a domestic violence application and also on the orders, the aggrieved, they'll be named as the aggrieved or the respondent. So you might hear those terms throughout the presentation. The aggrieved is the person in need of protection, and the respondent is the person who the order's against or who has committed the acts of domestic violence. So when we're talking about domestic violence orders, on the next slide, if you've ever working with people and they're presenting you with copies of their orders, or you've seen copies of orders, there's a variety of headings on those orders, and these are some of the ones, the top 4 there that you will see. So if it reads protection order, final order, so that's an order that has been finalised in the magistrate's court, and generally those orders now are made for 5 years. There are times when parties will negotiate with police or with the courts and to get, especially where couples are still in a relationship, and there's the aggrieved has sort of backtracked a little bit in that they might not really think they need the order anymore for one reason or another, but they have been times where they negotiate shorter terms like 12 months or 2 years. So protection order, final order, like I said, is an order that has been finalised in the Magistrates Court and generally for 5 years. If it says protection order, varied order, final, so that means that at some point the original protection order has been to the court again and been varied, and that could be changing conditions on the order, either by removing conditions or adding conditions. It could be something as simple as adding a named person or the family law exception, which we'll talk more about in regards to the conditions on the order soon. If the order reads that it's a temporary order, that means it could be from when a PPN, like a police protection notice, has gone, or it's been the first mention of a matter. And generally, when a temporary order is in place, it's that the other party has only just been served, or a copy of the application hasn't had time to get legal advice and has the right to request at the first mention of application that they have an adjournment period to get some legal advice to find out a bit more about it. So that may read a temporary order. So that temporary order will be in place from the day of the first mention until the adjournment period, the adjournment date. And then again, similar to the first one, temporary variation of a protection order. So a magistrate may deem that if an aggrieved has applied to the court to add some conditions and have stated her reasons clearly, then the magistrate might consider it necessary to temporarily vary that order until the other party has sought legal advice. Doesn't necessarily mean that that temporary change or the temporary order will stay as same, because the negotiations happen between parties or between the police. Most of the time in relation to where a respondent and aggrieved might be trying to vary a police order and are still in a relationship and have taken steps. So the respondent may have engaged with a domestic violence service or some form of counselling or drug and alcohol counselling, and can provide letters of support from those agencies involved, outlining what the respondent has done, what steps have been taken to ensure that that original act, that incident, is reduced somewhat in likelihood of reoccurring, really. So we see that quite often in court at the moment. The magistrates are willing to give 3 to 6 months adjournments. They'll put some sort of temporary order in place, and they do take into account the logistics of the family or the couple. So if a couple are still residing together, the magistrates can be quite think outside the box and say, well, we'll just put a good behaviour in order. So there's still that order that protects the aggrieved in that if there is any form of what's constituted as domestic violence, it will still be a breach of the order, even though there might not be contact, approach, residence condition on that. And that allows the parties to engage in counselling and bring back to the court the work that the respondent has done. And the courts are more interested in what work the respondent has done more than, and quite often of course the aggrieved is more than happy to engage in some sort of counselling and will bring that back as well, but it's generally more the courts want to see what the respondent has done to improve the situation.
Yeah, that's yeah, where the court wants to see both parties is bringing it up to the next bullet point, the cross orders, where the police have taken an order out or requesting an order against each party. You'll also find circumstances where parties have privately applied for cross orders against each other. I can indicate with no exaggeration that 90% of the time there's family law proceedings on foot in those circumstances, and there's either a parenting dispute or a property dispute that's inciting the incident in those circumstances. But those cross orders exist, notwithstanding the provisions of the Act that require the court to consider which party is most in need of protection. But cross orders are also a very effective tool for negotiation, not unlike the undertakings when you're trying to resolve a private matter between parties, you may be able to, or I often negotiate with the other party to consent without admissions to cross orders. We'll get into consent without admissions here in a moment. But it avoids trials where findings may risk being made against each party. And as we've noted in that final bullet, the standard of evidence, the standard of proof in domestic violence matters is the civil standard on the balance of probabilities. So that's a much lower standard of proof than a criminal standard of beyond a reasonable doubt. If you're going to think of it in percentages, beyond a reasonable doubt, the court is 95% sure that a person is guilty. When it comes to the civil standard of proof, I mean, you could dial it down to the court is 51% sure that a protection order needs to be made, more likely than not that a protection order needs to be made. Now, one other comment I want to make about the domestic violence orders and the titles that you'll see on them is for those of us in the sector working with victims and with respondents, the title of the order can tell you quite a lot. If you have a protection order, varied order that's marked final, that tells you there's a pronounced history of final orders being made in a matter, either by consent without admissions or just literally marked protection order, varied order final, where the court has made a finding based on evidence against the respondent. And that tells you a lot. Again, same with the temporary variation of a protection order. That tells you there was a previous protection order in place and that something has changed. And it can really help inform how you approach, well, on the lawyer side of things, the questioning that goes into asking the victim about the history of domestic violence. But it is, and I raise that just so that everyone's aware that they need to very likely inform themselves about the history of what's happened with these various kinds of orders that are going to be produced.
So just also on that cross orders, I know a lot of you in the social sector, me included, find it quite bizarre given that what constitutes domestic violence is that one person is more in fear of the other, how a cross order can happen. And at one point when the legislation was changed, it became a little bit harder to get cross orders. But I think when you work in the courts for such a long time, you see a little bit of everything. And if there is a cross order in place, then that it really is where it can be where the police go out to so many incidences where they clearly can't see who is the perpetrator. Like one week it might be clear, the next week it might not be clear. So I've always been a little bit anti cross orders because I think that under the true meaning of domestic and family violence, there has to be one party who's in fear of their safety. But after lots and lots of cases, there is those times where it is really quite unclear and where cross orders are there more to try and keep the peace, because the police have lots of important work to do, and when they get full on ongoing call outs to the same address when there's tit for tat, then there's not a lot of other options.
And they're infrequent. They don't come up much.
Yeah, you don't see them that often, but they are out there. Okay, so who can a protection order help? So obviously the order is there to protect the aggrieved, but also on a protection order there can be named persons, and they can be obviously children or stepchildren. It doesn't have to be the couple's biological children. Other relatives that may have been threatened, or associates, so maybe flatmates, workmates, friends. So, but for each person that's named on an order, there has to be a reason. So that the child might have been exposed to acts of domestic violence between the mother and father, or the aggrieved and respondent. Relatives will have had to have either been threatened or getting harassed, like through forms of, if the aggrieved blocks contact with the other party, then that the respondent may be taking up to other ways to try and contact the aggrieved, and that can sometimes be through relatives. So relatives can be named on there to prevent that ongoing intimidation and harassment, or the indirect contact. And associates could be that that they've been into work and constantly harassed workmates about where the other party is, or even a flatmate. You know, if they're in danger of, they've threatened that I'm going to burn the house down with you and your flatmate in it, or your new partner. All of these people can be named on there, and that they can be part of what the order is, or who the order is protecting.
Yeah.
So on an order, you will quite often hear the magistrate refer to an order as a standard order or mandatory conditions. So an order just in the standard terms or mandatory conditions just means that the respondent has to be of good behaviour towards the aggrieved. If there are named children on there, that the respondent be of good behaviour to the named children. And a third condition that's added on a standard order when there's children is that the respondent is not to expose the children to any domestic violence. And when they mean expose, that doesn't just mean that it's witnessing the argument or being caught up in the middle of a physical altercation. That can mean overhearing, so the children might have gone to a bedroom and locked themselves in a bedroom, or could be asleep in their rooms when the altercation or the incident commences. So it can be overhearing the incident. It can be cleaning up, helping a parent clean up after an incident. So the smashed dishes, the broken phone, the glass. Yeah, seeing the aftermath of an incident. Consoling a parent. You know, if a child has to console a parent, or, you know, ring the ambulance for the parent, anything that's exposing that child or the children to domestic or family violence.
What's the next one here?
So other extra conditions, so that's a standard order. Other conditions that can be added, the top one is always residence, so separating the couple if they're living together, if that's not working for them, or as you can see there, works or attends. The ouster condition doesn't get used so much on final protection orders, but is more used on PPNs, the police protection notice, to get that person out of the house then and there.
Yeah, that's, and the reason for that is because an ouster in the residential condition, you can see that's a bit of a double up.
Yeah.
If the court applies the residential condition on a protection order, that is effectively an ouster. So
yeah. So the ouster condition is used more as like an immediate thing on a PPN to just get them out of the house. And when the final order is made, it's generally termed that the respondent not attend any place where the aggrieved or named persons reside. They can also add works or attends. So, and they generally don't go any further than attends. They can add the school or daycare when there's particularly where incidences occur at school or daycare, like verbal altercations or physical altercations in front of the children at the school. The big three on an order normally are reside, contact, and approach. So the contact includes by telephone, text, or internet, and can be direct or indirect contact. So that means no contact by those means or by third party. So a respondent then is prohibited from saying to the aggrieved's mother or aggrieved's friends, you tell the aggrieved, I'm going to do this or I'm going to do that. So that's an indirect contact, using a third party to try and get a message to the aggrieved.
Yeah.
Approach, we don't see a lot of meterages added in our court particularly. I know they're still around and they do get added in other courts. but it's very hard to police. And I mean, nobody knows exactly what 100 metres is or 50 metres is unless you get a tape measure out and measure it. So they're very reluctant to put on meterages for approach, and approach just means not to go forward approaching them. And we quite often explain to aggrieved and respondents at court that that condition means it's Rockhampton, we're locals, but Yeppoon, other areas are smaller communities. If you're shopping in the same shopping centre, and if the respondent was to lay eyes on the aggrieved, then their correct is to remove themselves, turn around and walk the other way. If they bail. Once they've locked, spotted the aggrieved, if they don't make a concerted effort to leave the area, if they still continue to approach you, then that's a breach of that's approaching.
Yeah, and adjacent to sort of the approach and contact clause, it's open to the court as well to order the respondent not to try and locate the aggrieved. That generally, that's a pretty rare condition, and is also sort of difficult to police, but it's also in there. And then the last bullet brings us to
recovery.
Recovery is straightforward. The court can make an order allowing the respondent to task a job with police to go and recover undisputed property from the former residents.
Generally personal belongings, like clothes.
It's straightforward.
Yeah.
And the police handle that. So the final bullet there is the consent without admissions basis. Now there's something that's very, very important about that, which is why I have it in red. Whenever you're dealing with protection order matters, naturally it's an emotionally charged issue. And like I foreshadowed as well before, it often intersects with a lot of family law issues. For respondents, and not all of it, I have to represent respondents frequently, and I'm sure many support services in attendance today also have to assist respondents. Some that are actual perpetrators, some that find themselves on the tail end of vexatious litigation. It may be those rare circumstances where a cross order is being sought. Nevertheless, the tactical move when it comes to consent without admissions pays off for a respondent if they have to then turn up later, or maybe there's 2 rounds of litigation happening at the same time in the federal circuit court, because the last thing a respondent wants to do is turn up in the federal circuit court talking about parenting issues when they have a protection order that has been made against them at a trial after a magistrate has tested the evidence that's against them. So if they negotiate and consent without admissions to an order that's being sought against them, that order itself is not evidence that any domestic violence has taken place. And so that naturally becomes a very valuable tactical move for a respondent to resolve litigation early and focus on in this circumstance, this hypothetical that I'm talking about, the federal circuit court proceedings, which would be on foot at the same time, but B, as well, avoiding a finding being made against them, and that affords them a bit of protection insofar as they can then have that argument effectively in front of the federal magistrate without any sort of prejudice by that order. Okay, so it's a great way to resolve litigation in the magistrate's court, but it is also an extraordinarily valuable tactical move that the respondents that we're assisting need to be aware of. And naturally, by raising that issue with the respondent, that benefits the aggrieved because they don't have to be brought to a trial. They'll never be cross-examined by the respondent, but that doesn't matter. A trial is still an incredibly taxing experience emotionally, and the time costs, the stress, the impact on their quality of life. Anything to avoid a trial is to be desired. So be aware of that. And if questions come up about that and you're helping a respondent, the best thing you can do is refer them for legal advice.
I think there was a question in there about where and when can or should people be seeking help. Look,
Always.
we're always going to say, and it's a cliche, like knowledge is power. So the sooner you get them into services that can tell them their rights, and that includes legal advice.
Yeah.
The one thing they can rule out then is threats by the other party that I'm going to do this and I'm going to do that. If they get their legal rights, if they find out what their rights are, then they can, you know, rule out and think to themselves, okay, well, I know for a fact that they can't do that. So, well, the next slide is about the family law exception. And when we're talking about extra conditions on a domestic violence order, when there's biological children involved, when there's children of the relationship, then it's sometimes, and depending on the level of domestic violence that has been incurred, it's sometimes appropriate, or most times appropriate, to add an exception to perhaps mostly the contact and the approach condition. The magistrate will quite often leave this family law exception off a residence condition so that the aggrieved and children have a safe place, because they can still organise around family law orders and parenting arrangements to not attend the house. They can do changeovers, as most people know now, at schools or in police stations, McDonald's, wherever there's video cameras, that sort of thing. So quite often the magistrates will not add the family law exception to the residence, preferring to add it to the contact and the approach condition. So you can see the family law exception there, and it is that. And I think there was another question in there, something about parties breaching it when they're attending counselling. So if you're working with a family and this exception is not added to the contact and approach condition, then either party, the respondent or the aggrieved, can apply to the court via an application to vary to have this condition added. And that will allow for mediation, as it says there. Sometimes the family law exception won't read to that extent. Sometimes magistrates tweak it a little bit to help parties.
Magistrate Beaconsdale always does a custom family law exception. She will not use a pro forma family law exception. She always does it specific to the order.
So this one just says that it allows, the condition will read that the respondent's not to contact or approach the aggrieved except,
yeah,
and then this
is the pro forma family
yeah.
law exception, what we've got up there in italics.
And like, yeah, so some orders will read slightly different, but yeah, this is the overlying thing. So
yeah, now in the second bullet, where we say family law orders override orders made in the domestic violence court, what that means is in relation to the contact for children, it does not, if a family law order is being made in the family law courts or the federal circuit court, that does not obviate, it doesn't remove the domestic violence, the protection order. The protection order is still in force, but if the protection order does not contain the family law exception, and there is a subsequent order made in the federal circuit court or the family law courts that says the parties are meant to be facilitating time between the respondent and the children, they should be complying with that order. Okay, so just to read, if there's an order from the federal circuit court or the family law courts made after the protection order is made, they should be complying with that family law order, as it is a federal court order. It's a higher court, so it overrides the DVO. And those courts as well, they have conditions, clauses that they include in their own orders that take into account sort of retroactively the terms of any existing nationally recognized protection order.
So I know we're kind of running out of time and we don't have a lot more to go through, but I just quickly wanted to address a couple of questions that were in relation to domestic violence orders themselves. There was one here, it says, why is it so difficult for some people to obtain DVOs despite ample evidence given? I guess the biggest thing that we've come across is the amount of applications that come before the court that are not correctly filled out. They're not addressing the criteria that the magistrate needs addressed to tick the boxes that they have to tick legally to issue an order. And they're those things that I spoke to about previously, is that they have to be satisfied that a relevant relationship exists, which isn't a hard box to tick when there's been a relationship, that an act of domestic violence has occurred. So, and you need to, if you are helping someone fill out an application, you need to address the acts of domestic violence as set out in the legislation. Yeah.
So that question is a little
yeah.
So it's sort of answering its own question. They think they have ample evidence. If the magistrate's not convinced, guess what? That was not ample evidence.
Yeah.
And that's, again, we're getting the legal advice, because particularly a lawyer is not a social worker. So I often describe, and I use these terms when I talk to clients, I'm like, I'm not going to use kid gloves with you. And I tell clients when I'm reviewing their matters, I'm like, look, this is what cross-examination is like. And I test them. And that can sometimes be confrontational for them, but I've got a pretty good bedside manner, so don't worry about sending your clients to me. We do it gently, but we test that evidence to make sure that it is evidence of actual domestic violence, not bad parenting, not adults having an argument. If the evidence is there, the magistrate will be convinced, unless you get the magistrate on a completely bad day, which they're human, they have bad days. But quickly moving to the mediation bit.
Just quickly wanted to say on that, it's not about just writing in the application, there was physical violence, there was verbal violence. You have to actually stipulate what happened.
Yeah.
And if you can put in the date and the time, even better. You have to be specific. You can use swear words, you can use the actual physical things that happen. The more information, the more likely that you are to get it.
The more information, the better. Now, when it comes to mediation, this is again one of the important intersections between family law and protection orders. Because the family law exception requires there to be a written agreement between the parties, that can just be text messages between them. That can just be anything jotted down on a napkin. But the problem is that when the order starts and it contains a do not communicate clause, well, you can't exchange those texts. That's where parties will either be seeking to have the family law exception added, or they might do the application to vary a protection order to add the family law exception to allow them to go to mediation. Mediation is the preferred place for parties to reach that written agreement about parenting of the children, which is called a parenting plan. Now, just as recap real quick on the slide there, it's any written agreement in any form of writing, text, email, napkins. That's a parenting plan. The reason why they're able to be so loosely defined is because they're not enforceable at law. There's no penalty for breaching a parenting plan at law. If you end up in the family law courts, the penalty is, well, if you're the one that's breaching the parenting plan, the other party's equipped with that evidence against you, and you're gonna bear the brunt of it. So where it becomes an issue with protection orders is if there is a previous parenting plan a previous parenting order in place, and then a DVO is made later, and the parties then have to start talking about parenting plans to activate a family law exception. If that family law order predates or comes before the protection order, where the parties have to really be careful. And again, this is where, if you're seeing this issue with your clients, you need to get them in to see a lawyer quickly. That parenting plan that they come up with later to activate the family law exception on the protection order can permanently vary the family law order. And the problem with that is that variation, that parenting plan that's doing the variation, is not enforceable. And that is the whole point in having a family law order, is that you have enforceability from the court. So parties really need to be careful that they're not shooting themselves in the foot when they're trying to juggle this balancing act of, okay, well, I have a parenting order from 2011, but you know, the DBO took effect in 2015, and well, you know, and then now we're doing this parenting plan because the kids are a little bit older now, and oh, all of a sudden I've given up my alternate weekends with the children due to this parenting plan, and now the ex is not making the kids available to see me, and there's nothing I can do about it except restart litigation. So it can really go sideways in a hurry. So again, we raised that just to show that's probably the hairiest intersection between protection orders and family law, and that is if you see that come up with your clients or those people that you're helping, get them in for some legal advice.
So just quickly, and before we answer a few more questions, because I see that we're running short on time, the next slide, we have a lot of people that come through, and this is probably more for services. When you get a client that says, I've been to legal aid, they can't help me, I'm conflicted out, or there's a conflict. So just quickly, I won't read over these slides, but what I'm going to explain to you is about conflict. So legal aid is a legal firm, so therefore we can only help one party, we can't help both parties. That doesn't mean the other party isn't entitled to legal advice, free legal advice, and to apply for a grant of aid for ongoing matters, whether it be domestic violence or federal circuit court family law, mediation, parenting. So what happens in a matter of conflict is that a person will attend the office to apply for a grant of aid, like fill out a legal aid application form, or they will come in looking for free legal advice. If our office has already helped the other party, they will receive a letter that says that there's a conflict, and with that letter will be a list of preferred suppliers that we will refer them to, or they can refer them to, but so they are still entitled to their free legal advice. They get to choose a supplier from the list of the people that assist with legal aid work. So if you have a client that comes to you and says, oh no, I can't get help from legal aid, then start asking some more questions. Did you get a conflict letter? Were you referred to a preferred supplier? Have you gone and done that? If they're entitled to the free, everyone can get free legal advice. That's not, what do you call it? It's not money-wise checked. You're entitled to free advice.
Yeah, you don't have to test the means test.
The means test, yeah. It's only when you're applying for a grant of aid for ongoing matters mentioned like trials and hearings that you apply for a grant of aid. In those cases where people are gainfully employed and have a means to pay for their own legal representation, that could be a reason why a grant of aid is denied.
Yeah, so that conflict can be anything that provides either legal aid itself or the solicitor that's acting, that's employed for legal aid, an unfair advantage over the other party. So just having any knowledge of what makes them tick, that's a conflict. So it can be many things, and it comes up a fair bit. But the slide is there. You can have a quick look at that. The next slide had something interesting on it that I just quickly cast my eye over. So if a conflict arises, the person that has the conflict will get a conflict letter that'll be sent out to the preferred supplier, and they'll get the help that way, even if it's for the free advice and just the free advice. They can get that conflict letter. So for the services, I don't know that I think we've covered a lot.
I'm not sure how much time we've got left, but just a couple of things that I wanted to address in the DVO and conditions one. Charlie can speak to more to the others if he thinks he hasn't.
No, I think we've covered all.
Recognise them. There's how do you protect and agree from coercive control through mediation that permits contact with the shared children? And I'm not sure that this is a well-known fact, but you can, as a social worker, as a domestic violence prevention worker, you can apply to the mediation service for the aggrieved to have a support person. You need to be a silent support person. You need to complete forms to say that you will be silent and not interrupt in the proceedings. You can organise a shuttle interview, so the parties arrive at separate times, leave at separate times, and are in separate rooms. Or you can organise for, if you're concerned for safety, phone interviews. So hopefully that's where you were headed with that.
Also, the good behaviour condition on the order is always there, and
if they're not of good behaviour,
that's a breach.
Yeah.
So it's from a certain point of view, it's not up to the social worker or the lawyer to protect that person. It's the police, and any breaches of the order should be reported to the police.
And that answers one of the other questions, processes around breaches. The only people that can bring forward a breach is the police. So if the breach isn't reported, they can't do anything about it. Breaches have to be reported for the police to be able to assist, and they will guide you through that process in regards to what they need to make a breach come to court.
Yeah, and that brings me to a really important point that I say to all of my clients these days, is that because a response to domestic violence is always contact the police, the existence of the order for the aggrieved sort of doesn't matter, because they're always going to be reacting, or they should always be reacting to that domestic violence by contacting the police. So it then raises the question, who's the protection order for then if that response doesn't alter, I should say, if the protection order doesn't alter any behavior on behalf of the aggrieved or the respondent? And the answer is the police. From a certain point of view, that protection order is for the police, so that when they're dealing with the situation, they can look at the terms of the order and they understand how to do their job. Okay.
One of the other ones was how that they can keep children and women safe after a domestic violence order is taken out. And I think the biggest part you can do is educate yourself about high-risk behaviours. So myself and a couple of other organisations around town are in a process of putting together a high-risk behaviour information session. So keep an eye out for that. But there are lots of indicators of high-risk behaviours that happen during a relationship, after a relationship. It's about educating yourself about that and the people that you support. Those people need that information, even the basics of what domestic violence is, so that they're aware of what a breach is. So I think that's the biggest thing you can do to help with them. What are the other slides there?
Louise and Charles,
Yeah.
there is a few questions that have come through that I thought I'd just get you to answer if you could. One of them is just a statement, and it was from Lily Campbell, and she said that a lot of the time she finds the police are not willing to support to complete the application. That was the feedback from clients. So that's one of her comments. But the other thing that she's asked is, can you do an application for DV online?
So the answer to the online thing, yes, you can, but my understanding is that you still need to print it and lodge it with the court. You can't lodge it because you have to sign it in front of a JP and have it verified. And you have to get it set down for a date. So you need to, while you can fill it out online, you still need a form of printing it and taking it in. You can contact the court and see if you can email it to them and then ask them if they'll print it, and you still need to attend court to sign it.
The court's really good about that, by the way.
In regards to the police, the thing with the police is that they need to know that whatever they put before the court, that they're going to be able to get across the line. So if there's not enough information, if there's not enough evidence, they're being upfront with you that they're not going to get it over the line. And the thing that I used to do with people when they were coming in and filling out private applications, I would say to them, look, I can help you, but I can tell you haven't got enough information here. There's not enough stuff that constitutes domestic violence, or whatever the case. It's up to you whether you go ahead with the application. But the one thing I asked them to remember was, if you're in front of a court, you've called, the respondent has to attend, well, they don't have to, but they're given the opportunity to attend. Do you want this to be another point where they have control over you, that they've got away with it, that the magistrate says, no, there's not enough information here, I'm not going to issue an order? And I think that's something that was the biggest thing when I was helping people fill out applications, is that if you're not honest with them and say to them, look, there really isn't enough here to get them over the line,
It's part of
So,
the test.
yeah, look, honestly, I can tell you lots of really good stories about the police. So,
Cool. One more question is that
I hope that
it's
answers.
regarding the conflict of interest. So what if one party sought legal advice first and the other party can't access, okay, I've got another question coming for you, can't access the same service due to conflict of interest? What options does the other person have in terms of getting legal advice as well? And I think you did answer that, but just, it was a question that was raised in the middle of that.
That's the conflict letter that we spoke about before.
And the list of preferred suppliers that they will be able to
They
seek
can
help
get that advice.
Yeah.
Okay.
Did
There's
you have
another question come in also. It's about new residential tenancies and rooming accommodation regulations that state a tenant has a right to leave if they have no longer feel safe to continue to occupy the premise. They are required to provide evidence and can provide or show the leaser or agent a copy of a DVO, temporary order, DVO, PPM, family law. So report, which is a standard RTA form that can be completed by an authorised professional. My question is, can you provide any guidance to DVO workers in completing this report? And that's from Rose Brown.
Oh, yeah.
There was a lady that gave some information from the residency.
Yeah.
And we have a guy in town up at the building that would tenancy that would be able to help with that.
Yeah. So when these residential tenancy questions come up, and they have a couple of times over the last sort of 12 months, they don't come up often. We do tend to refer them out to the RTA. But when it comes to drafting, since the question was about drafting, there's one tried and true way to go about that, and this is actually super important if you're helping anyone fill out their information. One thing you got to remember about the legal process is, you know, we talk about court like an institution, like it's some kind of machinery. It's not. It's people. It's a person who's really jaded, and their eyes are tired, and they're dealing with complicated, you know, odious sort of matters. It's true of the police. Like when you get the pushback on them not wanting to do the application on behalf of somebody else, they don't want to because it's hard, and they just don't want to deal with it. You know, they're a person. They have bad days. It's the same with the court when they throw you a curveball on. You know, you have a lot of evidence and you're putting it to the magistrate, and the magistrate just doesn't want to hear it. It's because they're a person. So when you're dealing with that kind of a situation, and you'd be dealing with it with the RTA as well through QCAT or whatever, the best thing you can do in terms of assisting someone, particularly the vulnerable clients that we have that may be, you know, they may have intellectual disabilities, learning disabilities, they may have left school early, their education is not great. The best thing you can do is draft your information in the same manner that I draft an affidavit, which is using short, numbered paragraphs that are in date order, and they're limited to 1 or 2 sentences per numbered paragraph. Okay? And they're almost in bullet point style format. And when you're putting that information to whatever third party is going to read it, whether it's the court or the police or the RTA or QCAT, you write as though you're trying to explain the situation to an 8-year-old. And that makes sure that the information that you're putting across is simple and easy to digest. Because again, you're putting this information in front of someone that's, you know, living life, and they've got their own issues and their own trouble, and they're doing their best at work to be objective about things, but they need to ingest that information quickly, and that information needs to be as clear as possible. Okay, brevity is a virtue. Now, that also brings me to the other point that I want to say about that information and the evidence that gets put before the court. When you're putting a statement in a DVO, when you're putting a statement to the RTA, you are not telling a story. Okay, your statement is not a story. It should be a map of information, and that's where those short numbered paragraphs come into play. so that when whatever authority figure you're speaking to about it, and they say, well, where's the bit where they say that they, you know, smashed the glass in the kitchen and, you know, she ended up with 12 stitches in her foot as a result, you can immediately say, that's a paragraph 27 of the statement. It brings them right to it. And again, that helps whatever authority figure ingest or digest that information quickly. Okay, so the evidence that you're putting forward in support of the clients is a map of information. Okay.
Now, did you want to address any of the other questions?
We really covered off on a lot of them.
Well, I don't know about that one, 24.
24.
We're just having a quick look at the questions that people have set in to make sure.
There was one question about, does a family law order override a child safety directive order? The answer is it's kind of no. That's the classic lawyer answer. It depends. If there's a family law order in place and someone has made a notification to child safety, the family law order doesn't remove child safety's authority to step in and take the child where there's a substantiated claim. So from that point of view, no. But if there's been claims in the past and all sorts of concern reports have been issued and child safety's been involved, and a family law court order is made afterwards, well, that order would have been made in consideration of all those concerns that have been and the evidence that would have come from the child safety and those sort of things. So from that point of view, the answer is, well, yeah, it can. It's a federal court order. But child safety always retains its duty and its authority to step in and remove a child that's at risk. That's an interesting question. I've literally in 11 years never seen that kind of a conflict come up. I'm sure child safety sees it all the time, but that's a pretty unique scenario.
I think a lot of the other questions that we've got, I'm hoping that we answered them. There's a lot of them that the questions, you need more information. There's too many alternatives or too many things to answer them. So we've seen our contact details. If we can answer them a little bit better at another point, that's okay. Don't mind that. Now, just to wrap up, there's a few other slides about how to access legal aid for help. There's our offices. We have offices all around the state. I guess most of you are located locally and you would know where we are, which was on a previous slide. We are open face-to-face now to the public. So if you're interested in finding out about other webinars that Legal Aid present, you can keep up to date. You can subscribe to the link. Legal Aid has its own YouTube channel. We have plenty of online social media. I think there's Facebook, Instagram. I don't know. I'm not up with all of that stuff, but we have everything. Twitter, Legal Aid is everywhere. Our website has a plethora of information. It's amazing. Lots of stuff about DV, family law matters, and lots of stuff you can download and print off, like publications. Now, finally, I think there was something here about a survey. It says, finally, don't forget to fill out our survey at the end of this webinar. It only takes a couple of minutes and helps us to tailor our content and choose further or future webinar topics. If you have any feedback or questions, you can email them to webinars@legalaid.qld.gov.au and the team will send them through to us. Yes, whatever. Together we'll work it out in our own professions and see how we can answer them. That's it from us. Thanks, Ed, for your help. Thanks for attending. Hopefully keep an eye out for our next presentation around town. And if you need a face-to-face presentation with your team, if someone there's one person has been from a organisation that thinks it would be great for us to come out and deliver personally to your workplace, let us know. Okay, we're out. Bye.